Dr. Sam Stewart. Dr. Stewart is a pediatric cardiac intensivist at the Stollery Children's Hospital here in Edmonton, Alberta. He completed medical school and pediatric residency in Ontario prior to moving to Alberta for his ICU fellowships. He's received postgraduate training at the University of Oxford Centre for Practical Ethics. Without further ado, I pass you on to Dr. Stewart. Thanks again for being here.
Thanks, Michael. And thanks everybody for inviting me to speak today. I been long overdue for a talk to the center. And if you haven't met me before, as Michael said, I'm Sam Stewart. I'm one of the peds cardiac intensivists. I picked this topic as it's something that's comes up frequently in my day-to-day life, and also is something of interest during my postgraduate training. And I have tried to pull together sort of a brief overview of sort of past, present, and future ideas for informed consent, pulling from historic picture and present day bioethics literature, as well as my own personal thoughts and anecdotes thrown in there. I have no disclosures to make regarding this talk, and I'm hoping to chat for about 40 minutes or so, and maybe a little bit less, but to make sure there's lots of time to discuss and have questions. So the objectives of this talk are pretty straightforward. I'm looking to speak a little bit about the history of informed consent, discuss its status in present day, including some of the challenges that are faced by both clinicians and researchers when it comes to informed consent, and give some future thoughts on what things will look like and are looking like moving forward. This is a lot of information trying to boil down into an hour, so it's certainly not going to be a fully comprehensive review, but hopefully I touch on most of the major points as we go through. So I wanted to start off by going sort of as far back as we typically go when we talk about issues relating to medical care, and that's with the Hippocratic Oath. The Hippocratic Oath has and remains a mainstay in medical education. Many schools still use it, or a version of it, I should say, as students graduate from medical school and move on to residency. The idea being to pay homage to this historic figure who had contributed in many ways to medicine still to this day. When we think about Hippocrates, in general, there's a big overall focus on beneficence. And this is true sort of physicians in the day, where sort of the ancient Greek philosophers and physicians. And at the time, there was quite a paternalistic view on the practice of medicine. And shockingly, that didn't change for quite a few centuries. But there's nevertheless some things to be learned regarding medicine from Hippocratic teaching, and particularly around the areas of informed consent. The other major figure that we often think about from sort of an ancient Greek perspective is Plato. So in his dialogue, Laws, Plato describes what makes a good physician. He proclaimed it a moral imperative to consider the whole patient. He discusses the difference between freeborn and slave doctors, wherein slave doctors would work more empirically, treating diseases based on their experience, while the freeborn doctors, quote, dealing with the course of the ailment from its origin and surveying the natural constitution of the human body. The quote describes a common doctor of the day coming across what they're describing as a freeborn doctor and laughing at the holistic approach, where they're, instead of just dealing with the factual, there's an element of taking a holistic approach and confronting the whole human nature. There are certainly some issues with Plato's view on the matter, and he certainly had missed the mark a bit when we compare it to present day understanding of what it means to be informed and to provide informed consent. At the time, for Plato and physicians of the day, the doctor's primary duty was to improve the health of his patient, no matter what. And so trickery and deceit were thought to be acceptable at the time, as long as it was employed to the end of improving the health of the patient as the physician saw it. This kind of thinking is commonplace throughout history and for centuries beyond Plato and Hippocrates, and specifically the idea of benevolent lies. So right into the 18th century, there are a couple of major names in terms of physicians and philosophers and ethicists whose writings contributed greatly to some of the more modern ethical codes that we see and have adopted. Both John Gregory and Thomas Percival, mid to late 18th century physicians and philosophers, advocated that deception was morally justified when done in the patient's best interest. And so obviously things had not changed much from Plato to Percival. In fact, most of Percival's teachings in terms of Thomas Percival's writings made it into the initial AMA Code of Ethics that was originally published in 1847 by the American Medical Association. The majority of this was either directly quoted or paraphrased from his writings. And while informed consent does not make an appearance in that ethos of medical ethics, there were a number of things that the physicians of the time were focused on, namely uprooting and speaking out against quackery, which is published multiple times when you read the original text of the Code of Ethics. So they may have been at the time a little bit too busy with quackery to talk about informed consent, but it does come later. And as we move into sort of the early 1900s, there were a number of sorry, I missed a quote here. The other piece that was quite significant in terms of the time of Percival were some of the quotes he made regarding avoiding things like gloomy procrastinations, prognostications, and that it is a sacred duty to guard himself and to avoid all things which have a tendency to discourage the patient and depress his spirit. So this idea of benevolent lies maintained quite pervasively through the medical literature. This sort of continued on through into the early 1900s, and there were a number of sort of landmark cases regarding legal cases regarding consent that sort of paved the way for patient autonomy and the idea of informed consent, which wasn't going to come for a few decades still. So the first, one of the more well-known cases, from the early 1900s was Mary Schloendorf. She is a elocutionist from San Francisco who was in New York and was admitted to a nonprofit hospital after presenting with abdominal symptoms. She stayed in hospital for a few weeks, and in that time, physicians identified a mass in her abdomen. It was unclear what the exact origin of the mass was, so she consented to evaluation under ether, but prior to consent, as the records show, that she refused any kind of surgical intervention. While she was under ether, their surgeon identified a fibroid tumor and elected to perform a hysterectomy to remove the tumor and the uterus. And following this surgical intervention, she suffered complications, namely developing gangrene of her hand and requiring finger amputations. At the time, she sued the hospital, and the case made it all the way to the New York Supreme Court. This interestingly led to a landmark legal opinion by Judge Benjamin Cardozo, the ruling in 1914, and he's quite well known for having legally established this idea of patient autonomy. Um, and the quote from him in his ruling was that every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits assault, for which he is liable in damages. Interestingly enough, despite this exact writing coming in the ruling, he made this ruling with regards to the surgeon at the time, but he actually dismissed the case on the grounds that the charitable hospital, which in New York, could not be found liable for the damages. And while establishing a legal precedent for consent, there was nothing at the time that gave any kind of necessity for that consent to be informed. And I'm sure no one would be surprised to find out that around the same time, there were a number of other legal precedents regarding consent. And many of them involved physicians and surgeons making unilateral decisions, mostly on or regarding women, and failing to obtain consent for things like hysterectomies for seizure disorders and the like. So this, while this gets a lot of credit for establishing patient autonomy, it really, when further reviewed by some ethicists in sort of modern day, when you review the ruling itself and the text of it, most of the focus is on how the charity performed and how dismissive the text is regarding the patient's case and the plaintiff's case, saying that her testimony was essentially not worth the paper it's written on. So as I mentioned, this was one of many cases that sort of established this idea of consent, but not yet informed consent, in order for physicians to provide care to their patients. Fast forward a few decades through World War II. At the end of World War II, there's a famous trial known as the Doctors' Trial. And this is the first of the World War II war crimes tribunals, which occurred in Nuremberg. And this trial itself named 23 defendants. 20 of them were physicians, and it occurred over 7 months. And a majority of them ultimately were found guilty of war crimes and murder. But a lot of interesting points were raised, and challenges to the prosecution's arguments with regards to the fault for these war crimes. Some of the defense arguments were made that these physicians were simply acting in the good of the state, and that might take precedent over the individual, which would have been sort of in keeping with the Nazi regime, although I'm not an expert on the regime. The defense also compared the American military experiments on prisoners studying malaria in the United States to what was happening in Germany, and to try to shift the blame from the doctors to the state, to try to get these physicians off for their crimes. A number of notable ethicists were brought in, or experts in physiology and ethics were brought in. One such, Andrew Ivy, was an American scientist who, in the context, in the setting of his cross-examination, acknowledged that there were actually no written principles of research in the United States or elsewhere that were globally dealt with human subjects as testing on human subjects. And so one of the biggest significance of this trial was that it became clear that there existed no previous standard code of conduct for experimentation in humans. It also became a turning point in terms of separating the concept of consent for medical therapy and medical intervention, and consent as it pertains to experimentation on humans for advancement of science. Um, for those of interest, some of the famous experiments done by, I should say, infamous experiments done by the Nazi regime included sort of testing in extreme environments, high altitudes, as forced drinking of salt water, tea water, purely to test the effects on the body. And many patients died in a result of these testings, which occurred in concentration camps. So the panel of judges decided after this trial that it was a ripe time to put forward what has now become known as the Nuremberg Code. This was introduced following this doctor's trial. It consists of a set of 10 research principles, which I won't go through all of them in detail here, but it's centered on the protection of human research subjects. The first of these principles is probably the most relevant to this talk, is that the voluntary consent of the human subject is absolutely essential. Namely, that the individuals have capacity, exercise free power of choice, and comprehension of the elements of the subject matter involved, so as to enable them to make an understanding and enlightened decision. And while going through all of the principles isn't beyond the scope of this talk, and you can certainly disagree with many of the principles or parts of the principles as they were put forward, this was a very crucial document that established sort of a international, say, idea of what it meant to require informed consent without actually using the term informed consent, which will come still a couple of decades later. Despite this, and evidenced by further issues in North America, particularly, they continued to be experimentation and what we would now consider to be profoundly unethical experimentation on human subjects that carried through the Nuremberg Code. This slide has two images which represent the fact that the need for informed consent persisted beyond the Nuremberg trial. On the left is a picture from the Tuskegee syphilis study, where Black men, African American men, were followed longitudinally to monitor and describe the natural history of syphilis. And what made this profoundly unethical, well, many things made this study profoundly unethical, was that this persisted beyond the point of discovery of penicillin, which could have easily cured many of these men. And they were not given treatment in the name of studying the natural history of the disease. And then a little bit closer to home, on the right, is a picture of children from residential schools in Canada, and what was later uncovered to be highly unethical school nutrition experiments on residential school children. These were conducted across the years of sort of 1942 to 1952. So again, crossing that the Declaration, the Nuremberg Code, and carried out by high-ranking physicians, the Superintendent of Medical Services and Indian Affairs, and a nutritionist and president of the Canadian Pediatric Society at the time. So it's not just overseas, it's not just in the United States, but these kind of very unethical issues continued to persist. And the Nuremberg Code, as far as I know, still to this day has never been adopted by any nation, though it was a significant driving force for the development of a number of other codes or declarations that we do still use today. And some of them you'll recognize, the Declaration of Helsinki. This is a declaration that focuses on the obligations of physician investigators to research subjects, and the federal regulations for institutions, which emphasize the obligations of research institutions. Example for close to home would be the Tri-Council Policy Statement in Canada for ethical research on human subjects. And so all three of these sort of take this issue from a different perspective when it comes to research, but all three of them have as one of their sort of principal principles the idea of informed consent for human research. But again, while some of these had came out later, obviously, it still wasn't until the 1970s that the term informed consent was first put in the literature. There's a few other important legal landmarks that occurred over the 1970s, 50s to 70s. The first was Salgo v. Leland Stanford, this at Stanford University. And this was a patient who won a lawsuit against Stanford, claiming that he wasn't adequately informed of the risks of a procedure which left him paralyzed from the waist down. This decision, 1957, was, sorry, I believe I said the 70s before, but 1957 was the first coined term of informed consent. And this decision laid down the duty of a physician to disclose all the facts which mutually affect his rights and interests and surgical risk, hazard, and danger, if any. Physicians being physicians are having to be dragged kicking and screaming to the idea of informed consent. The next case in 1972, Canterbury versus Spence. This is where a neurosurgeon failed to disclose the possibility of paralysis again following a procedure, and instead described the procedure's side effects as potential for weakness, so as not to deter his patient from undergoing spinal surgery. This ruling was significant in that it created a shift in the landscape where prior to 1972, the majority of these decisions were based on what a professional practice standard would be. So what a fellow physician might describe as reasonable. And this was the first time that actually a judge deemed that no, it should be based on what a reasonable person would consider significant. So disclosure needed to be based on exactly that, what a reasonable person, not what a reasonable professional. And some have argued that this actual case has been one of the reasons, one of the shifts towards a much more litigious medical legal culture. And then, interestingly, Tom Beauchamp of Beauchamp and Childress, the sort of famous bioethicist who put forward the 4 principles of bioethics, He writes in a review from 2011 on informed consent, all about physicians having to be essentially brought into this world on, ironically, non-consenting of having to provide informed consent. Um, so, um, Additionally, there's sort of two major cases in Canada, Hop v. Lep and Ribel versus Hughes, which similarly to the Salgo and Canterbury cases, but in Canada, establish the reasonable person standard when it comes to disclosure of information. So over the course of the 1950s through the 70s through present day, you get this boom of growth of the new field of bioethics, and alongside it, the attempt to describe the importance and the need for informed consent and to break it into its principles. So that's sort of the historical piece. And then when we talk in terms of present day, the litigious aspect of informed consent certainly drove a great deal of change in the medical community. The concept is much more easily put into writing and guidelines than it can be achieved in reality. And with that, I sort of will give you a bit of an anecdote. When I was a trainee here, and I don't give this story to sort of throw anybody or units under the bus, but I was doing a rotation on a particular unit, and I remember being at the patient bedside, a patient who was intubated and sedated, but who would otherwise have had capacity to make decisions, who was sitting next to his partner and wife, and who was not in any kind of duress, or not any more than you would expect, with her husband intubated. Um, and the patient was going for a procedure. He was going for a PICC line, which is a percutaneously inserted IV that runs centrally. It's a procedure that's often done in interventional radiology. Because it's a procedure, it needs to have consent and the practice of consent. And I'm standing there with the wife next to me, and the husband sedated and intubated. And the bedside nurse turns to me and says, "You need to, have you filled out the two physician consent form yet?" What do you mean, two physician consent form? This is and I've put a copy of it up because this is a specific case where in emergencies and a substitute decision maker is not available, physicians can uh, provide consent on behalf of a patient following, as long as the certain criteria are met. And so only of the three criteria, I think none of them applied, if maybe one. But certainly that procedure was not emergent, was not necessary to preserve this patient's life. And the third, which didn't make it on the screen, but that they had not previously objected to this. I don't know if he would have previously objected. I doubt it. But I don't say this, like I said, to sort of badmouth anybody. I think it really highlighted to me what the sort of litigious culture of informed consent and what it means to provide consent, and how there's a huge push to make sure that this quote legal document has been signed, when that's not really the idea behind informed consent at all. Um, so many modern day bioethicists have attempted to provide a comprehensive argument for informed consent and what makes it such a valuable principle. And I have really broken it down and tried to simplify it. There are papers who describe it in many more ways, but I've tried to clump them into sort of three main categories or principles. The first, autonomy, which I've put in quotation marks because not because I don't believe that autonomy exists, but because I think many bioethicists would be angry with me for the subcategorizing of autonomy and the things that I may have included within that category. The second category is the idea of trust. And then this third category, which I've included because it's so relevant, as I mentioned on my last slide, is this institutional legislative requirement. So autonomy, and you could talk ad nauseum about how the many ways that not autonomy can be described. But I think fundamentally, most people in medicine and healthcare have a concept of autonomy. And for most, I think it's assumed to assume that it relates to their right to self-determination. The autonomous individual acts freely in accordance with a self-chosen plan. And broadly speaking, there are some other principles that I've lumped in with autonomy, and those are so autonomy is as one of the four core pillars of medical ethics, the others being beneficence, non-maleficence, and justice. Um, but autonomy itself, it gets extended into the fields times in ways that become harder to defend. So when we talk about autonomy and we're making decisions on behalf of a child or an infant, are we respecting the child's future autonomy? It's hard to say. Or are we respecting the prior autonomous wishes of an individual who can no longer demonstrate autonomy? There's a lot of literature around this, and you could read and discuss it with a philosopher over a beer in a pub any day. When I talk about self-ownership, this is a concept of the self as property, and people, we hold rights over ourselves, and requirement that we need to give permission even for interventions which are safe, low impact, and clearly beneficial. And so things such as even just giving blood, we can talk about things like implied consent or in implicit consent, by simply offering your arm and to the individual drawing the blood. Non-domination is another topic in the literature that speaks to the inherent power differentials that we could exist in our system. Certainly, the physician-patient or nurse-to-patient, or many of the relationships that we see in healthcare, existing for one to exert control over another. And then the idea of personal integrity, and that you have this, it's similar to self-ownership, and that you have the right to protect yourself and your space, and that in order for that space to be invaded, we need to provide permission. The other broad category in terms of principles for informed consent is one of trust. And I think this one's actually quite important, especially in this day and age. You can have different types of trust. Future-looking trust, there's this important and ongoing need to maintain trust in our medical institutions. Beyond just the doctor's office or hospital, but in our public health systems and medical research. And if we betray this idea of informed consent, and break that trust, we can do a lot of damage to the system and to our colleagues and our patients, in trying to provide care moving forward. The other way you can look at it is backward looking. The idea being that informed consent is an important way to honor the trust that a patient has placed in their healthcare provider, and as a part of that fiduciary role that the healthcare provider has undertaken. And then the prevention of abusive conduct certainly isn't a standalone reason for informed consent, but it is an argument for one. How do you define abusive conduct aside from the clear episodes where you have assault or battery? It becomes a little bit challenging, but certainly the informed consent can play a role in preventing such conduct. And then the last category, and this is by no means a fully comprehensive assessment of the various principles that may contribute to informed consent is the institutional or legislative portion. And that's this sort of idea of these consent forms that we have in our day-to-day lives. This or you could argue, or I would argue, that this is where bioethics probably should separate itself from the law a little bit. And while the law has significantly driven advances, as we sort of talked about in the history of these bioethical principles, in particular informed consent, the law really is only providing a minimum standard to meet, not the ideal that we should strive for. Beauchamp, in one of his reviews of informed consent, discusses the existence of it sort of categorizes separately as a legally or institutional effective approval, in a way to sort of differentiate it from the informed consent as an ideal, which is essentially the lowest of bars to meet. Looking at all of those things together, I think you can hopefully take away that there's a lot of strong reasons to honor this relatively new, when you look at the history of medicine, idea of informed consent. And then I often will try to reflect on simply those principles when I think of myself as a patient, and how they will how important the idea of being informed and providing adequate consent to for any procedure. We'll all be patients someday, or have been. The criteria for informed consent, which is taught in many professions, is this idea of content disclosure, and one could argue that there's a distinction between simple disclosure and comprehension. In fact, there's sort of legal precedent for and sometimes disclosure of risks and benefits being adequate to meet that minimum bar that we talked about. The risks and benefits of what a reasonable person would want when we talk about that reasonable person standard. The idea of voluntariness. This is, I'll talk a little bit more, but in substantial absence of control by others, and then having capacity, referring to the ability to understand and appreciate the consequences of the decision or lack thereof. Now, you could talk for an entire hour or longer about capacity. I'm not going to get into the details of it today, but it's certainly one of the major criteria for informed consent. So hopefully with that, I sort of shared a bit of why informed consent is so important when it comes to respecting people and respecting their autonomy, and maintaining the trust in our patients and our colleagues and in the healthcare system in general. As we sort of move forward into present day and beyond, there's certainly a lot of challenges for informed consent, which is, I'm sure, where a lot of people struggle at work. And just categorize those into the main two components. So there are issues with voluntariness and when it comes to informed consent. And these can be sort of categorized as coercion, undue inducement or enticement, no choice situations, and sort of an own waiver, the concept of own waiver. So coercion, where you're making a threat that makes somebody worse off than they are unless they consent. I think there's some clear cases where you could argue somebody is being coercive, and they're easier to identify and probably rare. But the others are a little bit more subtle. So undue inducement is a reward or benefit offered that's so significantly it can disallow proper consideration of risks. Thinking of a patient who is a palliative course or has a terrible terminal diagnosis, and someone offers a research study that has a drug that might save their life. There's this concept of undue inducement. But that similar situation also plays a role in these kinds of no choice situations. And one of those we see actually very commonly in our unit, no choice situation for informed consent, um, uh, where some of our small patients who undergo cardiac surgery will come back to the ICU with their sternum still open, as it was for surgery, just to keep space for swelling and have it closed either 24 or 48 hours later. And I always find it almost comical that the next day when we go to close the chest, the surgeons, because it's technically a new procedure, they have to go and consent the family for a chest closure, which is absurd because they really have no choice in the matter. The patient's halfway through a procedure. It's like going to the mechanic and asking them to fix something that they have to take your car apart for, and then them asking you the next day, well, do you want us to also put your car back together? And like obviously I would have thought that would be part of the original consent, but because of the way our litigious system is set up, there has to be a second consent. And then own waivers is when somebody waives their own right for informed consent. This is idea of can be seen in research settings where you could foresee somebody giving permission for future use of my blood for any future study, and that can and has historically run into some issues where communities have been affected as a result of sort of genetic testing that's done on blood samples that were collected for a completely different purpose. Um, when it comes to comprehension or that disclosure piece, uh, there's always a challenge we face as healthcare providers in providing adequate information, distilling complex information that we've spent years sometimes coming to understand, and then trying to distill that in the course of a conversation for X procedure. We can be guided by this reasonable person standard, but it remains very possible that for any number of reasons, level of education, language barriers, health literacy, misinformation or disinformation, a patient can't or will not understand the information provided. On the flip side, there's a number of studies that have shown the idea of informational overload is a thing. You have too much too fast can overwhelm somebody's decision-making capacity. And if forced to make a decision, it's at best not meeting our ideals for informed consent, and at worst, it's coercion. If consent for a research study is overly complicated or the burden of providing enough information, it's just not realistic. That can lead to issues with this being fully informed is just not realistic. I think what often gets challenged here is when we talk about substitute decision makers or surrogate decision makers on the behalf of an incapable person. In my world, that's a pediatrics or infant patients. Without getting into the specifics of capacity, it is important to remember that maybe these thresholds need to be a little bit higher for the person acting in the role of substitute decision maker, because separate from their own familial or personal relationships with the patient, they do have a fiduciary one, and that's a sort of a legal responsibility to act in what's quote the best interest of the patient. And so maybe the standards need to be a little bit higher when making a decision on somebody else's behalf. And certainly, while there's this legal standard that we must meet, there's only so far that this legal proceedings will progress these issues. Where what we want to talk about is not what's legal or illegal, but what is right and what is wrong. And until we can talk about those requirements as separate but complementary, there's always going to be a space for these individual consents for X procedure, Y procedure, and I'm not trying to minimize that there is certainly importance there, but I think when we, instead of looking at it from these sort of very discrete principles, if you look at all of this from a relational ethics perspective, where we try to take into consideration the whole patient, including their relationships with their family, their friends, their community, and how those relationships impact their decision making, their understanding. And we think of informed consent instead of being these individual, discrete events, but instead, for those of us who have the privilege of working longitudinally with patients and families, it can be a much more rich process than these just discrete events. Um, Gaining an understanding of how an individual's relationships plays into their decision making process makes it more of an exchange of information rather than a dissemination of information or disclosure. And every conversation that you have at the bedside is, in fact, contributing to informed consent. And some families or some patients will take longer to get there in terms of their understanding. And sometimes we won't act with fully informed consent, and we will be doing just sort of the bare minimum because of the situation, meeting sort of that legal standard. But I encourage you to think instead that all of these conversations that we're having are contributing to that broader sense of the informed aspect of consent. We practice in an imperfect field, and there's going to be times where we don't get it right. And interestingly, I thought about this as I was doing putting together this presentation last night. I went online and used an AI generator for these pictures. That is, on the left is an image that AI has done of Plato and Hippocrates shaking hands, and on the right, future of medicine. But I think as we move forward into this world of dominated by machine learning and AI, questions of morality are going to become the forefront, and really we should be on top of the basics before and as we move into these more complex issues. Thank you.